let's go to our next session. The next session is called Drafting and Prosecuting Patents for Enforceability. So let me give our next speaker presenter right so he can bring up his presentation. So as I'm introducing Daniel Fleisher, Daniel can bring up his presentation. So speaking on this session, dealing with drafting and prosecuting patents for enforceability, is Daniel Fleisher. He's an associate at the law firm Hamilton, Brook, Smith, and Reynolds. Usually when we have these conferences, I like to invite partners to speak, but I had the pleasure of working with Daniel about a year ago on a matter, and he was so knowledgeable about the intricacies of drafting and prosecuting patents that I figured he's going to be a partner very soon anyway. So why not invite Daniel Fleisher to speak to us today? So Dan, thank you so much for joining us. We're really looking forward to your presentation.
Yeah, thank you, David. I really appreciate that fantastic introduction. Again, hope I can live up to the billing. And again, thank you. It's a real honor to be here today as part of the conference and presenting on this topic. So with that being said, I think I'll get right into it. This is just a little bit of background about the firm, the areas that we work in, and the different services that we have. Just a little bit of my biography. So as you can see, over time, I've worked in a couple different capacities in the field. Right now, as was mentioned, I'm been an associate at the firm coming up on about 2.5 years now, doing patent prosecution, some litigation, other aspects of IP strategy and counseling. But before that, I was actually at the USPTO working as an examiner in an art unit for computer engineering. And then before that, I spent some decent amount of time as an IP litigation associate, a big national firm. And then just before that, before law school, I had a number of years working a career as a software engineer, and I got my master's in computer science in the middle of all that. So hopefully I can present some couple different perspectives and maybe offer a few things that folks will find useful in this topic. So I'm going to jump into the agenda. This is what I'm hoping to cover today. And that being the case, I will dive right into the introduction. So I think, in my mind, patent value can be maybe formulated or considered in terms of 3 different quote unquote pillars. Some of these folks may consider that they overlap, but you can start with validity. And again, there's some folks would say there's overlap there with that and enforceability. But to me, I would mainly consider validity to be talking about 2 different areas, withstanding challenges to the claims that are based on prior art, so novelty, obviousness challenges, and withstanding invalidity challenges that are based on other grounds, such as 101, written description and enablement, and so on. Then moving to the next pillar, you have enforceability, which again, to me, that's talking more about technical defenses to non-infringement based on specific aspects of the accused products or services, legal defenses, things like maybe divided infringement, and of course, equitable defenses, things like inequitable conduct being a major one, also different types of latches. On top of that, I think falling under the enforceability category, you would include things like maintaining ownership and or standing to sue to assert patents in the first place. And then lastly, the other component is broad coverage, so capturing a wide range of infringing activity, whether that be through literal infringement or doctrine of equivalence. And as the entire theme of the conference states, at the end of the day, we want to maximize remedies, be they damages, injunctions, licensing amounts. So, that's what we really want to get to at the end of the day. This is the road to maximizing damages. This presentation is sort of one of the first steps on that road. Of course, there is a little tension between the three pillars, because if you try to emphasize validity and enforceability, you may have some trade-offs with broad coverage. So we're trying to strike a good balance between all those three considerations. Now, again, folks may have some different views on what is and isn't the definition of a weak patent, but there are certainly some risks that everyone, I think, would recognize in terms of invalidation or unenforceability. For example, with the American Invents Act, we have different types of post-grant proceedings. Most prominent among that would be inter partes review. So I think the statistics here pretty much speak for themselves, but you can see for 2024, you have a little more than 2/3 of petitions being instituted, and then petitions that reach a final written decision, again, a little more than 2/3 of those cancel all claims in the patent. And then if you take into account partial cancellation decisions, then adding that, you get to 84%, which is quite a large number. And then in terms of costs, in recent years, we're talking about somewhere around $300,000 to defend an IPR proceeding all the way through at least final written decision. In recent months, and generally, there's been a few developing trends at the USPTO that may be a little more beneficial to patentees than in the past, but there are other things on the horizon. For example, ex parte reexaminations have been around for quite some time relative to the AIA proceedings, but those may be coming up on the horizon to fill in the gaps if IPRs become less of a thing. And then, of course, we always have the federal courts, and you can see since the Alice CLS Bank decision in 2014, when a 101 decision is appealed to the Federal Circuit, through the last 6 years after Alice, we're talking about close to 80% of those decisions invalidating the patents. So I'm going to take this, try to take this in terms of a timeline. So the first point in the timeline is pre-drafting before we actually get into the drafting exercise in terms of preparing and prosecuting patents. So as one of those topics with pre-drafting, we have prior art searches. So of course, there is no affirmative duty to conduct a search. If you want to conduct one voluntarily, then you have the option to do that. And there may be benefits from a targeted search. I do say targeted because it's important that you have some idea of what you're searching for in terms of what are the core inventive concepts and what is the sort of essence of the invention. Otherwise, if it's not really focused, you probably spend a lot of time and money doing the search, and then more time and money maybe reviewing results, which at the end of the day may not be that relevant. But if you have a targeted search, you can definitely achieve some benefits. First and foremost is getting the best claims you can. You can see what is the closest art or potentially closest art, and you can make sure that your claims are avoiding that. And on the flip side, you can see what are the areas, the gaps in the art that offer opportunities, and you can focus your claim drafting on that. So, again, at the end of the day, you want to have strong claims when the patent issues, and this is a way to get there in the first instance. Another benefit, as I see it, is you're sort of replicating a litigation setting. If you're in litigation later on down the road, certainly defendants are going to be motivated to attack the patent at all costs, and they're going to do very thorough searches. So, maybe you're not doing quite that level, but you're getting somewhere close to what you might be facing from a defendant down the road. And then lastly, there's some, I think, positive optics just generally, and maybe for jury and judge appeal. It shows that this is a really thorough, well thought out, well-researched patent, especially if you're citing a lot of references on the face of the issued patent. Of course, there are some risks. You might find new art, and when I say new art, things that wouldn't otherwise come up in prosecution at the USPTO search, maybe even things that a defendant might not find. But again, it's sort of the principle of security by obscurity. You don't want to just chance it and hope that no one finds this art. Maybe it's better to just know about it ahead of time and proceed accordingly. They're also, again, thinking about the litigation on the horizon. There are discovery considerations, of course, about search results and then other records that relate to a search. And I think we're all familiar with the disclosure obligations that could come up with search results. Next, there are, again, in the pre-drafting phase, some considerations for inventorship. The basic standard is you have to correctly list the inventors on the face of the patent, and that's going to be based on who made a contribution to conception of at least one claim of the patent. Typically, if you have individual inventors, they will assign their rights to an organizational applicant. So you have to get inventorship right, and when you do get inventorship right, that has some benefits and good consequences. You may have prior art exceptions. For example, there are some prior art exceptions under 102B1, 102B2 that can turn on the inventorship for a patent. There's always efficiency when it's done right early on. And flexibility, you can consider if the inventors are going to be one way based on having all the claims in one application. Maybe you can put some claims in a different application and some in another one. And so you're not really manipulating inventorship, but just finessing it so that it can be cleaner across different applications. Of course, we're talking about ending up in litigation, and if there are issues or defects in inventorship, that can have some risks. There can be costs to correcting it. It can be corrected, but there are costs associated with that. There can be risks of invalidation if it's not properly addressed. One good thing about the AIA is that it made it a little easier to correct inventorship after issuance, in that you don't need to show that you lack deceptive intent when you're listing the original inventors. And then not in terms of listing inventorship, but just in terms of general considerations for who the inventors are as you arrive at litigation. Many times they're going to be party witnesses if they're still employed, or potentially third-party witnesses. So you can think about how they present as witnesses, what's their jury appeal like. You can consider if there's a level of skill being proposed by a party, you would look at the inventors and think, and ask yourself, do they actually meet that level of skill, based on what the qualifications are supposed to be? And then again, past statements and publications by the inventors, potentially come up in litigation. So moving on the timeline, we've covered pre-drafting, and now I'm going to get into some different considerations that go around actual drafting of the claims and the rest of the application. So generally, as I think many judges, but Judge Rich famously said, the name of the game is the claims. Broad claims are going to be helpful to support that pillar of patent value. There's many things that could be said about claim broadening and claim drafting, but I figured I would just list a couple highlights here. One is strategies for broadening claims. some people have different philosophies. Some people like to do an additive quote unquote approach. Some people like to do um, the opposite, where you sort of pare down claims. But in either philosophy, you can look at each element just one by one and think or question, is this really necessary? And some examples might be things that are part of the invention, but they're just optional. They're not really needed to practice the quote unquote core or essence of the invention. And things that could be considered quote unquote off the shelf elements. Maybe they're just conventional elements that are used with the invention, but aren't really necessary unless you just want to sort of have some basic context for just fundamentally understanding how the invention works. But those are areas to consider. And then as you move down to claims that are a little bit narrower, again, you might want to trade off the pillars between, for example, validity and claim coverage by having a few intermediate claims that maybe go to some specific implementations or potential competitor designs, but they're a little more specific to have a little bit more chance of validity while still maintaining a decent level of coverage. I think the takeaway here is you don't want to just broaden everywhere all the time as much as possible so that you can get some better balancing. And then lastly, you can have some very specific claims that cover really specific implementations or configurations. Again, where you're trying to move toward more of the pillar of validity. So if nothing else, you will have some valid claims at the end of the day. And then these are just a few sort of topic specific areas. As I talked about one-on-one, again, specifically keeping that in mind, you want to be careful because you can get broader and broader, but at some point, the more you go along that dimension, you can run into abstractness if you're not careful. And of course, that can be an issue with eligible subject matter. And then specifically with software and computer patents, you want to avoid or try to avoid things like generic computer components, and the MPEP has a list of examples of that. For means plus function claiming, similar idea. If you're broadening and you're getting into very broad functional language, unless you're doing it deliberately to have means plus function, yeah, you could unexpectedly be construed that way, and then you might not have corresponding structure in the specification for those elements, and as a result, you could have a written description or indefiniteness issue. So just something to be aware of. And then specifically for non-obviousness, and if you want to have objective indicia, like things like commercial success, again, the broader you make the claims, the more you have to think about, are you going to be able to maintain a nexus with whatever types of objective indicia you want to put forward? And of course, again, the end game here is damages. So consider what kind of different scopes of claims might match up to different products, or maybe different portions or different components within those products, and how that might affect the range of damages that you can pursue. So then, aside from claim breadth, then there's mixing and matching independent claims and dependent claims, and also the different types of claims. Of course, you want to have some broad claims that cover the core invention, as I talked about, but then you can also consider having alternative independent claims to go with your default independent claim. And by alternative, I mean different wording, different terminology to cover the same thing, but with a variation in claim scope to achieve some additional coverage there. You can think about with method claims specifically, whereas a system, you just need to show infringement of the components. Method, you may think about needing to show infringement of actually performing the method. But on the flip of that, a reference put forward for invalidity would, of course, have to disclose performing the method too. So there are trade-offs there. Again, you can leverage different types of claims, system, method, if you have computers or software, non-transitory medium, for again, variations in coverage to achieve a broader spread altogether. And then just one thing I find for one-on-one purposes, even if you have, for example, a method and a system which in effect have basically equivalent substance, sometimes it can just be better to lead with a system as your claim one, because it just sort of has a better optical appearance in terms of jury and judge appeal. A system seems a little more technical. Maybe folks on the jury might think, well, a method is something a human can do. And then lastly, different strategies for dependent claims. Again, you can have alternative implementations and configurations. You can target potential infringing systems or designs that you know of or that you're expecting. And again, you want to look at what are the potential design arounds and try to capture as many of those as you can right up front in the claims. And then finishing up on claims, again, this ties back to what I said at the beginning about searching. You can pursue find opportunity areas that you can pursue aggressively. As you go into prosecution for the later topics, you're only going to be narrowing. In most cases, you're not likely to be broadening. So you want to start out with as much as you can, with the expectation that you'll have to refine it over time to some extent. And likewise, you don't want to leave anything on the table in the first place because you're not likely to get it back later. I talked about 112F before. It can be helpful to have functional language in the place of specific implementations that you can cover other potential implementations, but again, just be mindful of mean plus function. Again, it's good to think about what are foreseeable trends in the industry, competitor designs, and target those accordingly. Again, the more aggressive you get, you're again balancing between the pillars. The broader and broader you get, you have to be more aware of things that could come up with 112A. By that, I mean written description or enablement. And likewise, might consider how that will have impacts on the priority date of claims that you're broadening as compared to other claims. So I'm just going to go through the other section of the application now, touch on a few points, starting with the background. You may want to have that be a little more focused or limited in contrast with other sections. You can keep in mind when discussing specific art, if that's something you want to do, that it could be anything in the background will probably be treated as an admission of prior art, even if it's not specifically identified as such. Of course, the MPEP says that anything that's designated as prior art anywhere in the application will also be treated as such, but the background is especially sensitive in that regard. Again, trade-offs between discussing general drawbacks of the art, which are good potentially to set up the benefits of the invention, but if you get too specific in the problem that's solved or a need that's identified, you might want to be careful because that itself can be part of what's inventive, and you don't want to give that away in the background. Again, likewise, it can be a helpful place to start supporting your themes that you want to carry through the application and all the way through to trial about novelty and non-obviousness. And the background is a great starting point to do that. And then again, just keep in mind how that will interplay with things like level of skill, scope of the art, and then for 101 in particular, what will that do in terms of establishing which elements are quote unquote well understood, routine, and conventional. So I'm going to spend 2 slides on detailed description because that's a big component. When it comes to claim construction, the legal standard there says that the specification is extremely important. It's quote unquote highly relevant. in construing the claims and the terms of the claims, and it may ultimately be dispositive. So with that in mind, we would like to take as much opportunity as we can in the detailed description and the specification to broaden the claims wherever possible. There's listed a couple ways to do that. Again, I mentioned functional language earlier. Give as many details as you can and different examples to support broad interpretation. Again, I talked about different operational modes, configurations, ways to implement the claims. When you are talking about examples, you want to make sure that you refer to them as clearly examples. And likewise, if a feature is optional, you want to make it clear that it's not required. You can use permissive or open-ended language like may, or some embodiments may do this. And again, if you're anticipating 112F or that may come up, you do want to make sure that you have broad equivalence, because a means plus function limitation is going to be construed as covering the structure and the specification and the equivalence. Likewise, you want to avoid things that could narrow the claims. So the flip side of permissive is mandatory language, like must, or things that are required, things that could characterize the entire invention that might import limitations into every claim or every embodiment. And then again, giving lots of examples, not just preferred embodiments. Otherwise, you could end up limited to that. And then there's just other opportunities in addition to broadening that you can take advantage of in the description. You can take it as a starting point to list out examples of objective indicia. For 101, you can list out practical applications, technical improvements, describe things that are non-generic elements. And for damages, even though, of course, advantages is a typical thing to include for non-obviousness, that can serve two purposes, and the second purpose can be supporting your technical damages theories. The idea being that when you get to litigation, the first place you're going to look for sort of your litigation roadmap is the specification. So having that stuff right there is really helpful for one-stop shopping, as opposed to having to go out and investigate these things, or at least as a starting point for further investigation. So finishing up with the last different components of the application before I get into prosecution, field of invention is not required, but if you're going to include it, you would want to consider if it's broad, to support and in furtherance of broad claim interpretation. A lot of the same considerations apply as for the background. The summary, of course, there's different approaches. Some folks like to just have literal support for the claims, which can be especially important in jurisdictions that are very exacting, like the EPO, for literal claim support. But also it's another good broadening opportunity in addition to the detailed description. And then the drawings, again, more opportunities there. They can also be used to do written description support. And again, talking about litigation roadmaps, if you're going to end up in trial, you're going to need trial demonstratives. And again, the first place you might look is the drawings. So if there are existing drawings, or you might want to have custom drawings to include, that's a great source of getting your trial demonstrative started. And it can even be helpful early on in the process, thinking of things like tech tutorials for claim construction. You know, you want to have good figures that can support that and other things. So I'm going to finish up quickly with two more topics. Prosecution, couple different philosophies and recommendations or areas for consideration here. Again, there's different styles and approaches and philosophies for responding to office actions. I think some folks definitely like to err on the side of less is more. That can be a good thing, considering that anything you say or any statement you make in the course of prosecution is an admission, potentially by the plaintiff that could come up later in litigation for better or for worse. One way to get less content on the record is to make use of examiner interviews so that less things are on the written record. But again, and having been an examiner, you have to make sure that you get buy-in or some understanding from the examiner during the interview about what's going on going to go into the summary, because the USPTO requires examiners to provide their own summaries for every interview. Other things that can come up with statements in prosecution are prosecution disclaimer, where you might say something that disclaims or reduces claim scope under the case law. And along the same lines, prosecution history estoppel could come up if there's an amendment that's made, in which case there's the potential there to lose the DOE for the limitations, the elements that were subject to the amendment. But on the flip side, there are chances when you can actually deliberately make a more favorable record. One example of that would be response to reasons for allowance. Sometimes folks don't really take advantage of that, but it can be useful to put really helpful things on the record for later. Generally, again, thinking about the end game of damages and coverage, you want to balance arguing rejections versus amending. The arguments, it's good to keep focus on what's insufficient with the references, as opposed to needing to characterize the invention in some way that might be inconvenient later on. But sometimes you have to amend to overcome a rejection. And I think the considerations there are just keeping in mind that in the short term, you want to get an allowed case, or you can't move further down the process. But again, you have to think, are you excessively amending such that even if you get claims allowed, are they really going to have a useful or worthwhile scope? Again, having been at the USPTO, an examiner will give you the straight story about how you stand with the rejections and the references, but it's really sort of outside their remit for them to tell you, are you going to have good claims or good scope if you do these amendments? It's just not part of their job description. And lastly, appeals, they can be time consuming, but sometimes it is a better option if, for example, the examiner just won't budge from an unreasonable position, as opposed to just pursuing more and more prosecution. Or if you have a really illegal issue, you might be better off doing an appeal than trying to butt heads with the examiner for that. And I will just finish off with a few other considerations that are sort of outside the timeline or adjacent to the timeline that I just talked about. And these have to do with patent families and foreign family members excluded as part of that. I think it's just an overall general consideration when you're dealing with multiple applications, family members, be they foreign or domestic, is just consistency. You want to make sure you have consistent statements, you're making consistent arguments, you're amending in as much of a consistent way as you can. Of course, you have to account for different jurisdictional requirements, but the aim is to try to be consistent, and that will serve you well, I think, in litigation and proceedings down the road. Different types of family members, I think folks probably have a pretty good feel for continuations and the uses of that, broadening, getting particular kinds of claim scope or claim coverage. And again, that can be another place where you can introduce the kind of what I talked about earlier of alternative independent claims. Of course, keeping in mind the issues that can come up with double patenting, terminal disclaimers to overcome that potentially, but then you have to think about patent term if that's going to be something you're worried about. And another thing I think that maybe lesser known is continuations are just extending sort of prosecution of the original invention. And so you can come up with new art new rejections as you have different claim scope going down the timeline. And that can, although not immediately necessarily impact the earlier issued patents, down the road, it could have some ramifications even for the earlier issued claims. Divisionals, of course, one benefit there is the safe harbor for double patenting that can be achieved if the divisional is done in response to a restriction requirement. Continuations apart, there can be useful, but there's definitely, I think, factors you have to be mindful of in terms of what is the patent term and then what's the priority date for the new matter that's in the CIP. Reissues, maybe not talked about, not as much visibility, but can be helpful if you want to correct errors. If it's 2 years within issue, you can try to broaden as well. And again, talking about the validity pillar, can be a little bit more favorable setting to address new references that come up because you'll have potentially some opportunity to amend there in an easier fashion. And then lastly, foreign filing. Of course, your targets or potential infringers may be more of a presence in overseas markets in case you want to capture that. And then just generally, you might want to take into account what are the different standards across jurisdictions. Whereas in the US, I'm sure folks are familiar with eBay in terms of getting injunctive relief. Some other jurisdictions may be more generous there, so it might be something to take advantage of. And I think that pretty much covers all the items I have for today. So
Great. Thank you very much. Very interesting
for
presentation.
bearing with me.
Sure. No, it was great. So we do have some time for questions. If you have questions, you can send them to me. In the meantime, a segue is your last comments about foreign filings. If one is focused on potentially asserting his patents in the United States, is it any better or worse if the patent was initially filed in a foreign country and then, brought over to the United States, or is it better that it's initially filed in the US and then other family members can be sought elsewhere?
Okay, so if I understand the question right, if you want to assert in the US, would you rather have the priority application be a US priority application or something based on a foreign application? I think I would have to give it some thought to give a really more considered answer, but I think I have some initial impressions. My initial impression, one of them would be, at least to me, as it's sort of a gut reaction, if you're going to be in the US, you probably want, or if you have a choice or a preference, you would probably prefer the priority application to have been filed in the US. And that's just because then you could think that at least someone of some baseline level of experience with US practice and US practitioner was going to have prepared that priority application, and they would be putting in and all the sort of things that you would want to have and taking into account the considerations that arise under US practice, and then they would be thinking about later applications that are based on that in the US. I think that's just sort of the first impression I have. The other is maybe going to more practical concerns for litigation. I guess if you have a foreign priority application, you're going to have inventors and evidence and things like that potentially all outside the US. That could be good or bad. I have certainly been involved with litigations where the priority application was foreign, it wasn't US. And I think from a patentee perspective, again, if the sort of the discovery evidence and the witnesses are not in the US, that can actually advantage the patentee because it will just be harder for the defendant to access that kind of discovery and access the witnesses in a convenient way for them on their terms, whereas the patentee, of course, wouldn't have to go through discovery and so might have an easier time of things. So I think those are just some considerations I have. And then, I mean, of course, I think maybe just goes without saying, if the priority application was not in English language originally, if it was some other language and had to be, there was a translation that happened along the way, that could certainly raise interpretation issues and translation issues between the U.S. later filing and the non-English priority application.
Some people have said that, for instance, the European examiners are more rigorous than U.S. patent examiners. Do you have any thoughts on that?
Yeah, I think that's definitely a good point too. I think, we deal with this all the time because we might have counterparts in the EPO, or we might start with a PCT and then do national stage. So, I mean, the PCT examiner could be the EPO as the ISA, the International Search Authority. So I would say, I think, and I've also been again in the examiner's chair, looking at cases that are national stages that have an international search report. I would say, I think it's sort of hard to sort of compare different requirements, but I think you can certainly identify areas where the EPO is more stringent, perhaps than the US, and vice versa. I think definitely if you have a favorable, for example, PCT international search report, I think that is a positive for prosecution in other jurisdictions, including the US. So that I think is a something that's optically good and positive for the patentee. On the flip side, though, just because the PCT report might have been negative, it doesn't necessarily have implications for the US because the examiners might just do their own search and examination, and they might not put a ton of stock in what happened at the PCT stage. So, but I think there are definitely contrasts that you can see between the different jurisdictions in some areas.
Okay. Well, let's have a few more questions. Go over a few minutes. We'll yield back time to Jennifer. She'll have her full time. Anyway, as far as inequitable conduct in AI, what kinds of issues come up there if one is too dependent on AI or is, crafting claims with the help of AI? Does that erode the individual inventorship?
Yes, I think, I mean, I think, we're all familiar, or probably folks who are thinking about these issues have been following the case of the Thaler case. That was a little different, where trying right up front to actually not introduce, but designate quote unquote AI system as an inventor in the first instance. So it's a little bit different scenario there, but I think these are issues that I think practitioners are definitely going to have to contend with. There is a potential there, I think, if you have, let's say you're using a generative AI system and the claim has elements A, B, C, and then there's an element D, and that's proposed by the Gen AI system in the first place. I mean, I think there is a serious question there of whether that system ought to be considered as one of the inventors, because there was contribution to conception of at least one element in one claim. And then, carrying on with that example, if that is the case, or if that's true, that it should be named, the system should be named as inventor, then I do think you have to, think long and hard about what you're going to do when you list inventors, and whether that might be getting into that territory of inequitable conduct if you don't list the AI system or do something to account for the fact that it contributed a claim element.
Mm-hmm. Okay, good. May sound like a silly question, but can drawings be copyrighted and people end up infringing the patent and the copyrighted drawings in the patent?
I think that is a good question. I think that could be a law review article in its own right. I think it's definitely a topic I've thought about. I'd like to research more and maybe write about. I'm sure it's been done. I think it's a very fuzzy gray area. And this goes also for when you're submitting non-patent literature as references in an IDS, because if those are copyrighted, arguably you're making copies of them just to submit to the USPTO for an IDS submission. But getting back to drawings, I think, if you want to err on the side of caution and say, hey, maybe the inventor sent me some stock drawings or stock images, maybe it's just an example of something in the prior art, just want to illustrate it for background in the patent. You might want to consider being conservative there and not maybe necessarily including that image verbatim in your drawings if there's a thought it might be copyrighted. We have a couple of ways to get around that. I think we can show, we can say to the inventors, can you make your own drawing like this? Just do it yourself. And a lot of inventors are pretty talented when it comes to drafting. They can just sort of recreate it without, having to make an exact copy. We could do the same thing with our drafts people, our drafts person, if the inventors can't do it for some reason. But again, I think it is a gray area, and a lot of folks want to be cautious there about respecting people's copyrights. And I think that ties into the Gen AI question too. We have Gen AI, we have fancier image searching, and we have generative image creation capabilities now. And if you're going to use that for your patent drawings too, I think you really should be thinking carefully about, what are the copyright implications on that as well.
Okay. All right. Great. I think we'll end the presentation at this point. Dan Fleisher, thank you so much for speaking to us and putting together a very thorough presentation. We really appreciate that. And I like to see, when I'm valuing patents, I like to see that the lawyer that drafted and prosecuted the patent has some experience in litigation like Dan. Most people can't keep abreast of all the issues Dan was speaking about, but I find it helpful when the lawyer that's drafting and prosecuting the patents is at least subconsciously thinking about how the patent would withstand an invalidity attack or could be asserted. So, okay, so let's end Dan's. You're welcome. Thank you for an excellent session, Dan. We'll end your session if you can stop sharing. That would be great.